All right, and I have a plea agreement in front of me as well. For purposes of arraignment, do you and your client waive the reading of the allegation?
We do, Your Honor. We have received a copy of the information. And we believe it's reading.
And is the forensic center referral requested?
No, Your Honor.
All right. All right, Mr. Misiac, would you please raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Put your hand down. Are you Nicholas Jean Misiac?
Yes.
Mr. Misiac, a guilty plea hearing is an important hearing because you waive rights that you have. So I want you to listen very carefully. If you have any questions for me, go ahead and ask. I'm happy to answer them. If you need more time to talk to your lawyer, you just go ahead and say so. Do you understand that?
I understand that.
Now I have to advise you the maximum penalty for the charge in count 1 of stalking a minor is a felony punishable by a maximum of 5 years in prison and or a $10,000 fine and up to 5 years of probation. Do you understand that maximum penalty?
Yes, sir.
Are you on probation or parole anywhere else?
No.
Were you on bond for any other case at the time of this incident?
No.
Did you read and understand the rights listed on the advice of rights form?
Yes, Your Honor.
And you signed that?
Yes, sir.
Do you understand that that lists the rights that you would have to a trial?
Yes, Your Honor.
And that if you plead guilty, you won't have that trial?
Yes, Your Honor.
Therefore, you give up all those rights?
Yes.
And is that what you choose to do today?
Yes, Your Honor.
If I accept your plea, you also give up any claim that it was caused by any promises beyond the plea agreement or any threats. Do you understand that?
Yes, Your Honor. Also,
When you plead guilty, you give up the right to appeal. And if you wanted to appeal, you'd have to seek permission to do so. You would do that by filing an application. Do you understand that?
yes, Your Honor.
Now, but when you plead guilty, the types of issues you could raise on any appeal are very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes, Your Honor.
All right, the plea agreement provides an exchange for your plea of guilty to that charge. There's a sentence agreement that you'd be placed on a statutory delay of sentence for a year. And during that delay, you'd be subject to different probationary terms. If you completed the delay, then the charge would be reduced to misdemeanor stalking with no jail on that charge. And also that this would be a non-SORA case. Do you understand that?
Yes, Your Honor.
Mr. Boyd, is that a full, fair, and accurate statement of the terms of the agreement?
It is, Your Honor.
Mr. McLennan?
Yes.
All right, Mr. Misiac, that sentence agreement is not binding on me. Meaning if I didn't want to follow it I don't know anything about this case. I don't know anything about you. At the time of sentencing, I'll know more. And if at that point I decide I can't live with this, then I don't have to. But if I don't follow this agreement, you would be allowed to withdraw your plea because you wouldn't be receiving what you bargained for. Do you understand that?
Yes.
There is a very important exception to that rule. Here's what it is. If you engage in any misconduct between now and the sentencing, by absconding on your bond, missing a court date, violating bond, committing a new crime, anything like that, then by your own misconduct, you would lose the right to withdraw the plea, even if I didn't follow that agreement. Do you understand?
Yes, Your Honor.
Means you do fine, you show up to court and I follow this, you're on a delay of sentence, no jail, and a misdemeanor at the end if you behave. If you misbehave between now and the sentencing, you show up, I could revoke it and send you to prison. You get that?
I get that. Yes.
Other than the plea agreement, has anybody promised you anything to get you to enter this plea?
Not at all.
Has anybody threatened you to make you?
No.
Is it your own free choice to enter the plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 1, stalking a minor?
Guilty.
Mr. Boyd, would you assist with the factual basis, please?
Yes, Your Honor. Thank you. Mr. Misiac, in June of 2025, were you acquainted with a person with the initials of KW? Yes. And did the two of you engage in a series of communications during that time? Yes. And were you in Presque Isle County at all relevant times during those communications? Yes. was the communication initially a mutually interested communication?
Yes.
And as we stand here today, are you now aware that KW was a minor at all relevant times?
Yes.
Okay. Did there come a time when KW told you to stop contacting her?
Yes.
And despite that, did you continue to communicate with her after she told you not to?
Yes.
Would you agree that she felt harassed by that communication?
Yes.
And would you further agree that a reasonable person might feel harassed by communication after being told to stop communication?
Yeah.
And at all relevant times, were you 5 years or more older than her?
Yes.
Judge, I think that's a sufficient factual basis.
All right, you agree, Mr. McLennan?
I agree, Your
And
Honor.
Mr. Voida, you're aware of any other promises, threats, or releasements?
No, Your Honor.
Mr. McLennan?
No, Your Honor.
And Mr. Voida? In your judgment, has the court fully complied with the requirements of MCR 6.302?
I believe you have, Your Honor.
Mr. McLennan?
Yes, Your Honor.
Mr. Misiac, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I hereby accept your plea. We'll schedule sentencing for March 16 at 10 a.m. Before you leave, you stop in to check in with probation agent here and get her card so that you can make an appointment for a pre-sentence report. You'll have to do an interview so I can learn more about you before the sentencing. And Mr. McLennan, any objection to continuation bond?
No objection.
Bond will be continued.
Thank you, Your Honor.
Is that all you have today, Mr.?
That's all.
All
Thank
right,
you.
you have a great day.
You too.
Get somebody on Zoom. Let me see who this is.
Sorry.
74F8, counsel, you want to state your appearances for the record, please?
Jeremiah Buffalo, work on behalf of the people.
Good morning, Your Honor. Chris Parks on behalf of Mr. Godfrey, sits to my right.
Okay, good morning, Mr. Goddard. Last time we were here, we had a little bit of an issue about some stuff you're doing in the courtroom. You've got the absolute right to be present in your courtroom for your sentencing, but you can forfeit that right by your behavior. So I just want to remind you, you and I are engaging in something and you and your attorney, and that's it. Okay.
I apologize, Your Honor.
No worries. Okay. All right, so we're here for a continuation of sentencing, and also we did do a show cause arraignment last time and scheduled this for hearing. I understood, Mr. Wirgo, you wanted to proceed. I'm sorry, is this Mr. Wirgo or Mr.?
It is not, Your Honor.
That you wanted to proceed with a contempt issue before we go forward with the sentencing, is that right?
Yes, Your Honor.
Okay. All right, and Mr. Parks, are you ready to proceed on that?
Your Honor, I've received no documentation from the prosecutor regarding the contempt. I don't know if they plan on presenting today, but I've not received any videos, any audio, nothing for a contempt hearing, Your Honor. So I don't know what the prosecution intends on presenting. I know we had 30 days for them to get everything together. When I spoke to Mr. Wirgo on Friday to see where we're at with the case, he said he was going to attempt to send me the audio recordings. I never received anything from Mr. Wirgo other than a corrupted file that didn't have anything on it. So I don't know what Mr. Wirgo intends to present today, Your Honor, but I would object as it's not been provided to counsel.
Okay, so you're asking for a continuance?
I'm not asking for a continuance, Your Honor. I just, if they're going to present anything, it should have been provided already. My client's been spending 30 days and has already spent 98 days in jail for this. So
So you want me to dismiss the show cause?
I do, Your Honor.
Yeah, I'm not doing that. I'll grant you a continuance if you want. Do you want it?
I have a moment with my client, Your Honor.
Absolutely.
Your Honor, my client does not want the continuance to like proceed today then.
Okay, Mr. Wirgo, you ready to proceed?
Your Honor, Mr. Parks is right. We did discuss this on Friday. In all fairness, he doesn't have this audio. If he doesn't have it, I believe my thought that the last we spoke, I resent it while we were on the phone, but I'll take him at his word that he doesn't have it. In fairness, I don't think that would necessarily be appropriate, Your Honor. I will just use the information and update the factual portion of the sentencing, the PSIR with it. I do not wish to proceed with an evidentiary hearing. Yes, sir.
All right, so you're giving Mr. Parks the remedy that I didn't want to give him.
Then I would ask for a continuance, Your Honor, so that he can have this audio. I feel bad sandbagging him if he hasn't seen the evidence. I don't think it's fair.
Well, I mean, here's the thing. What sentence I give Mr. Goddard for this charge that includes a firearm charge and a domestic assault charge. And it's not just a vanilla felon in possession of a firearm. It was a pretty assaultive situation, alleged that he held his wife gunpoint. What I do to him for sentencing might be affected by what kind of communication he was having with the victim while he was in the jail. So, I mean, I got to have that information to decide on an appropriate sentence. So he said he didn't want a continuance. So you can present the evidence today if you want.
Your Honor, I think that it would be unfair to do so.
Well, I don't care what you think about that. My goodness. Already determined he's not entitled to dismissal. But it's, well, I was certainly going to give him some jail. I mean, honestly, my notes, even before we had that issue, were looking at least 6 months jail. I mean, so he's not really prejudiced by a continuance. I'm continuing this. I'm going to continue this to March 16th at 1:30 in the afternoon. And I want to know what kind of contact he was having with the victim or not before I decide on his sentence. I mean, I suppose if the prosecutor just wants to abandon a contempt prosecution, I can't make you prosecute. So you can tell me at that date and time whether you want to.
I will not be abandoning, Your Honor. I strictly wanted to make sure the defense has that.
All right, that's my job. That's my job. March 16th, 1:30 in the afternoon. All right, Ms. Bennett, is that you?
Yes, sir. Christine Diana Bennett, 8853.
This is file 25-93364FH. And we're here for a docket call on Mr. Vogler. Last I knew, you were awaiting possibly an independent evaluation for criminal responsibility. Is that still the plan, and what's the status?
Yeah, it is a plan, Your Honor. Our expert met with Ms. Bennett, I believe on January 20th, he came up here. And in my communication with him, since that time, I asked him to put his report on hold to allow me an opportunity to obtain some older psychiatric records of my client. I will tell you that they may be difficult to obtain or may not exist anymore, but basically our feeling that it would give us a better psychiatric picture. Fine. That being said, I would ask the court, and whether I have to put this in a formal motion or not, regardless of how we proceed going forward on an insanity defense, I would be asking the court to stay the case pending the Michigan Supreme Court decision
On diminished capacity.
I see statewide that this is what's happening in various circuit courts, and people potentially want to put that defense on and don't really know whether it's going to be
Right, well. Right, oral argument was held in October. So I mean, I expect we'll get a ruling this term. All right, Mr. McLennan, people's position.
Your Honor, I would agree with Mr. Vogler on staying the case pending the outcome of the Michigan Supreme Court case that could have an impact on.
Well, I mean, I'm not sure whether at this point we need to stay it if we are. I mean, you're still gonna want to get those records anyway.
Correct.
So I certainly appreciate you bringing it to the court's attention. It would be a possible diminished capacity defense. My thought is we don't enter any order staying at this point. The only benefit to that seems at this point would be where I wouldn't get dinged by the state for time guidelines on the case, but I'm less concerned about that. As long as you're still needing to continue the docket call to allow you to get the records.
Correct.
So I haven't scheduled it for trial. Once we get to a point where we're ready to schedule it for trial, if at that point you want to not schedule it to await that decision further, I guess at that point, under that. Because they didn't grant leave, it was an oral argument on an application. So I mean, I don't know what they're gonna do. Sometimes at the end of that, they just deny leave.
oh, is that what that was?
Yeah, it was an oral argument on the application. Yeah. So I don't know. So it's hard to predict what's gonna happen with that. Well, maybe you want me to put this, I've got a call at the end of March 30th. You want me to do that? Give you
That'll be
a
fine.
couple months here to try to get those records. All right, let's continue it to March 30th at 9 a.m. Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Okay. See. All right,
Thank you,
Ms.
sir.
Bennett, you're all set today.
Thank you, sir.
All right.